Hey, magical listeners, welcome back to Miles Beyond the Page, the podcast where we go behind the scenes with authors, experts, and creative minds to explore the craft, the chaos, and the career of storytelling. Today's episode is especially important for writers, editors, and indie publishers navigating the ever-evolving world of copyright law. My guest is someone who wears many hats and wears them all well. Consultant, educator, former president of the Colorado Independent Publishers Association, and co-founder of Integrated Writer Services. Please welcome Dr. C. Daniel Miller. Thanks for joining us today.
Good morning. Good morning. Thanks for having me.
Thank you. Dr. Miller is a leading voice in copyright literacy known for making the complex feel approachable. He's the author of the award-winning Copyright Clearance for Creatives, and he's currently working on a second edition, which includes new insights on how artificial intelligence is reshaping the copyright landscape. Through his consulting firm, Integrated Writer Services, Dr. Miller helps creatives like us understand the rules of the road when it comes to using and protecting copyrighted material. He regularly speaks and teaches workshops on copyright basics and copyright in the age of AI. And trust me, you'll want to take notes for this one. So whether you're a seasoned indie author or just dipping your toes into the publishing world, this episode is packed with valuable information to help you stay informed, empowered, and copyright conscious in the digital age. So, wow, you've done a lot. So this is exciting.
I've been engaged for a while.
Yes. So what inspired your journey into the world of copyright and intellectual property law?
Well, I've got a deep background in education, so I've been involved in the educational process, going back to the old 80-column card punch to input data into mainframe computers. So I always have an interest in education, and I consider the presentations that I'm doing, and even the podcast like this, is an education process.
Mm-hmm.
So when I learn and discover things, I like to share those, especially when it's things as difficult as copyright, and then you add the extra layer of AI on top of that.
Yeah.
So I actually got into the whole copyright clearance process through my wife. She had taken paralegal training and all that, and started out doing copyright clearance. And then I got involved back in 2010. So I've been doing presentations on copyright basics since 2010. And we published the book that you mentioned before. We published a second book. I've advised a lot of people on business aspects of independent publishing. So that's really the background that I have. And I've cleared thousands of items for dozens and dozens, hundreds of clients, if you will, including attorneys. So I've actually had 6 attorneys as clients because they didn't deal with copyright or intellectual property law. So that's the background that I bring to the discussion of AI. So I see everything about AI through those lenses, basically.
Mm-hmm. Yeah. And it's not going away. It's pretty much here to stay.
It's starting.
Yeah.
We're in the frontier days.
Right. So what you've worked with authors, editors, and publishers. What are some of the most common misconceptions creatives have about copyright?
Fair use.
Yes, that's a big one.
I'm only going to use a little bit. It's got to be okay for me to go ahead and put 2 lines from a Beatles song in the cover of my book.
Yes, and that is something that authors always are wondering about. Like, what are the? Let's see. I know I have a question here about that. How can you avoid infringing on someone else's copyright, especially with images, quotes, and song lyrics, and quotes from like other books and whatnot?
Well, if you didn't create it and you find it, someone else did.
That's a good explanation.
If you use it without permission and it's under copyright protection, you just committed copyright infringement. Now, there's some exceptions to that, and fair use is the exception. But if you're not a news reporter and you're not writing a criticism and those kinds of things, fair use is a slippery slope. And basically, the decision is made by a judge, whether your use without permission was fair or not. And the odds are not good if you're writing a book and you just want to use somebody's stuff and you don't want to bother getting permission. You can face some severe penalties, financial penalties as well. So I'm a no fair use. I don't recommend fair use, and I explain why. But And that's a big thing that's hitting us with AI right now is it's all boiling down to fair use in the courts in terms of this big debate about AI using other people's stuff without permission or
Mhm.
reimbursement for that. So
Yeah, it's a hot topic. So, one of the other questions I have is what is the difference between public domain and fair use, and where do most people get tripped up on that?
well, public domain is something that either was never copyrightable or it lapsed into the public domain by age or whatever, or someone assigned it to where it's available. Creative Commons is where someone can assign it. Basically, they can put it out and say anybody can use this. Essentially, Creative Commons is a type of license, and there's 6 different types in there for that. So a lot of people use Creative Commons, but public domain stuff is a rich resource. Uh,
Mhm.
and starting several years back, every year there's a whole new trove of materials, if you will, that goes into the public domain, and you can use that at will. You don't need permission for that, but you better make sure it's in the public domain and not under copyright protection. So right now, it's anything in the United States before 1930 is in the public domain,
And
but you have to go back and find out when it was actually published.
and that's something that can be searched for? Is there, like, a database or something like that?
You see my name above my head here?
Yes.
It's not necessarily easy to find
Gotcha.
this out, but yes, you can do a search, and the U.S. Copyright Office is expanding the database, and they're actually bringing in additional material. So that's good news that
Mhm.
it's more searchable. Until recently, you could not go back further than 1978 in the database, and now they're opening it up with millions of more documents, so they're loading those into the system. But you have to, there's a lot of different sources I have to go to try to find out whether or not something's in copyright. And since we're talking about I use AI a lot. So when I'm doing research on this, I use Perplexity Pro as my go-to for
Mhm.
it. But I like it. It cites the sources and all those kind of things. So I'll use that particularly to try to find contact information. Say someone passes on, well, who's the heir in the estate that actually has the authority to grant permission? So I'm seeking permission. So I had to find out who it is and how to get in touch with them. And that's part of the big challenge. That's how it
Mhm.
came up with the name of Copyright Detective. I was talking with a marketing person about this. They said, yeah, this is just pure detective work. And she said, well, that kind of makes you the copyright detective. Bingo. And there's the other side. There is an R above that.
Yes.
So it is a federally registered trademark. And that's another point of confusion. So what's the difference between a trademark and a copyright?
Yes.
And it's apples and bowling balls. It's two totally different things, but
Ye
they're both a form of IP protection.
yes, and trademarks have come into play with authors too, as, they wanna trademark their titles or their series or whatever. We've seen that happen in the past few years. So, can you tell us a little bit about what integrated writer services and what you do for clients?
Well, we basically assist clients in unraveling the mystery of copyright issues with their words. Hopefully, they get in touch with us early in the process. If they come to us after the book is already in print, that's a lot of water under the bridge that we have to figure out how to deal with, and that does happen occasionally. But typically, they want us to identify content that they want to quote or copy directly, and then we'll determine whether or not it's under copyright protection. If it is, a lot of times they'll have to reduce the amount of stuff that they're actually going to copy. I recommend things like paraphrasing
Mm.
or, cite the source, talk about it in generalities, but don't directly quote it. So most of the authors that come to me, too many quotes, too many little quotes, it actually is just detracting from the work itself because you're trying to figure out all these notes and footnotes and everything else rather than just to summarize. So and once we do that, we go out and we get permissions. We manage that. We look at the license, the terms and conditions in the licenses. We'll attempt to negotiate fees if the fees are unreasonable. We can advise whether they are or not. So yeah, it's once we get involved, it's our responsibility to attempt to get the right kind of license or grant for the person to use what they want to use, how they want to use it.
That's interesting, and so do you mostly deal with nonfiction authors or fiction authors as well?
Doesn't matter. Now, the nonfiction, they have a lot more sources and content and
Mhm.
everything else. with that. So not as much with fiction. Occasionally, someone will want to put an exact quote in fiction, or more likely, they'll want to put song lyrics,
Yeah.
especially baby boomers. We love to talk about music from the 60s and the 70s, and to sprinkle it everywhere. Well, you can use a title. You mentioned titles earlier.
Mhm.
A title is not copyrightable. So you can mention, Bohemian Rhapsody all day long if you want to.
Mhm.
Just don't put the lyrics in there because
Right.
they're going to charge you. And quite honestly, I try to talk people out of using song lyrics.
Yeah, I know that there's a lot of people who want to do that in books just to give it that feel. It's
Well, Freddie Mercury's a good, yeah, Bohemian Rhapsody is my favorite because there were 5 songwriters and 2 publishing houses.
Oh,
It's
wow.
you have 7 people that own 100%. Well, Freddie passed on, he left it to 5 other people. So now you have his 5 plus the original 4 plus the 2. So there were 11 owners to the song lyrics for Bohemian Rhapsody. And, yeah, do you think it was one place I could go to and get all that?
No.
So I try to talk about, and they've also raised the minimum rates now, so it's getting very expensive. 5 years ago, a lot of them had a minimum of $300, whether it's
Mhm.
one line or the whole song for that, and
Oh.
that's gone up. And don't even get me into audiobooks because it's getting up now, 4 figures to get permission to, because you need 2 different licenses to be able to use a song recording in an audiobook.
Oh, yeah, I can imagine. Yeah, that's interesting too, how that works. So, questions for, sort of the copyright 101 questions for authors. What is the absolute must knows for indie authors or any author really when it comes to copyright protection?
You mean protecting their work?
Yes.
Okay,
Yeah.
so there is a window of opportunity. When you publish, you should file an application for copyright registration within 90 days. 90. Get it done. Because if you do that, then you can reap, if someone infringes and you sue and you win, then you can reap a much bigger bonus. It could be up to $150,000 per incident. Plus, they have to pay your attorney's fees, and that's a
Okay.
biggie. Now, if you don't hit that 90-day window, you have to prove that you lost income from the infringement. And, that's a difficult thing to prove. So you get
Mhm.
minimal compensation for the infringement. So by all means, file the registration. And that's where AI gets to be really tricky
Mhm.
because you have to disclose how you used AI. If it's more, and I'll use a Latin term, more than a de minimis amount, and that's a small amount. So that's a whole conversation. I take up about 10 slides in my PowerPoint presentation talking about that one issue is
Mhm.
how much is okay and how much is too much.
Mhm.
But you do have to disclose, and you have to disclose it now with Amazon KDP.
Yes.
And if you don't disclose it and they find out, they can yank your book off the shelf. And there
Yep.
are publishers now that are also requiring the disclosure of its AI generated content. It's not AI assistance like Grammarly, but it's, when you're actually, if you start with AI and you're only using prompts, that's in the not copyrightable claim, if you will, from the
Mhm.
copyright office point of view. But there are a lot of ways you can use AI very beneficially that does not run those risks for uncopyrightability for you.
So this would be you would wanna copyright your ebook and your paperback? Both?
Well, it's different editions of the same thing. So,
Okay.
you're filing a registration with the Copyright Office. Now, an audiobook would be different, in terms of the ISBNs and all that, they're separate things, but, you're copywriting the work. In terms of my presentation that I'm doing now on this copyright in the age of artificial intelligence, we actually achieved copyright registration for my PowerPoint presentation and my presentation. And it has AI generated and AI assisted throughout. So I had to go through the disclosure process with the Copyright Office examiners, which is part of my understanding how this whole system works.
Mhm.
It's a bit confusing, to say the
Yeah.
least.
Yeah, it is. And you've recently been speaking on that, the copyright in the age of
Mm.
artificial intelligence. What are the biggest copyright concerns related to AI right now? I guess that would be the generate AI generated versus the AI assisted?
Yeah, if you think about those as the I have a graphic. I could pull. I don't want to pull up my PowerPoint presentation. It's actually sitting right below my screen here. Especially if you think about a graphic, if you think about a gradient. So on the right hand side of that is human authored, and that's the most copyrightable. On the other side of that, the opposite side is non-claimable, and that's when it's AI generated. And that's defined as when you start with a prompt and all the inputs you have into the AI platform are prompts, then the US Copyright Office is saying that is unclaimable. In other words, that's not copyrightable. So it's okay to use that. It's okay to put it in your book, but it's
Mhm.
just not copyright protected. So anybody could take that and they could use it as they wanted to for that. So that's the thing to keep in mind is it's no different than if you're publishing any other kind of a book. If I use a picture that I got permission from you to use,
Mhm.
my book is still copyrighted, but my copyright does not include your photograph because you already own that,
Got
or a
it.
quote from you or anything else. So this is just a new element. And I call it the fifth element because I really like that movie. So it's the fifth element. And you have to disclose when it was AI generated. And you do not have to disclose if you use Grammarly to clean up your language a little bit. Now, there's a lot of gray in between those two.
Mhm.
And that's where it really gets muddy, if you will. And an examiner is going to decide whether it is or it isn't.
That's interesting. So, and we've kind of talked about how current laws are a little bit handle this, and but can you give us more insight into how the current laws are handling content generated by AI? Nobody really owns that, right? I would assume.
So far, so the U.S. copy. So here's part of the issue. So Congress passes laws and the president signs it. Then the U.S. Copyright Office enforces those, and they
Mhm.
create the rules and regulations, etc. Now you can challenge that decision, and it goes to the courts. So the courts are the third leg on the stool, and they'll decide whether the U.S. Copyright Office whether they agree with that decision. And so far, they're in sync. So right now, there are three major documents that have come out recently from the U.S. Copyright Office. One deals with copyrightability, and that's really what I'm talking about for that.
Mhm.
So the last one that was just came out on the 9th of May deals with the liability of AI platforms. And that's where things are right now. And essentially, the U.S. Copyright Office has said this is going to be decided by the courts. That's the main thing.
Mhm.
And so I'll go back to 2015. Google was granted the right to copy millions of books without permission or compensation because the courts decided that it was fair use. It was transformative to create a database that's searchable. And Google put guardrails around that. You can't copy a whole book or anything else. So that's the fair use issue. And there are 39 court cases right now queued up against AI platforms. One has
Mhm.
been decided, and it was decided that the use was not fair use. And that just happened a couple of months ago. And that was the Reuters against Ross. Ross basically was trying to set up a competing platform, and they trained their AI platform using Reuters content. So that was a clear, yeah, that was a dumb move.
Mhm.
And the court said no. And was bankrupted by the court proceedings. So they're out of business. But
Wow.
so Reuters won it, but they have deep pockets. You're
Sure,
allowed
yeah.
to not have deep pockets to go after them. But so there's 39 court cases queued up. And the U.S. Copyright Office in the latest report indicates that they feel that some of the uses of AI are going to be found to be fair uses and some are not. Okay,
Mhm.
well, that's a roll of the dice. And historically, the court cases, it's about 51-49 in terms of whether it's fair use or not fair use. So
Mhm.
it'll take years to play out.
Yeah, right. As you said, we're just in the infancy stage here.
Yeah. Now there is
Uh-huh.
one big scary thing on the horizon. The big beautiful bill has a clause in there if it's approved, if it goes through the Senate and gets signed, where there is a 10-year moratorium on states being able to do anything, pass their own legislation or anything else. And my state, Colorado, passed one that would go into effect back in February. Basically, it's a consumer protection issue with AI platforms. So that's the first in the country to actually do that. And this big, beautiful bill would put that on hold for 10 years if it gets passed. I'm sure that'll be, if it does, it'll be challenged immediately, I'm sure.
Mhm.
And then it'll work its way through the courts and eventually it'll hit the Supreme Court. So ultimately, the Supreme Court is going to be the decider on these big issues.
Yeah.
Yeah.
Right. And so you did mention AI tools. Writers every day use Grammarly or a spell checker or Pro Writing Aid or AutoCred or anything like that. So what are the risks for authors and publishers using these tools? Are there any?
Well, the infringement is a possibility. So it depends on what you're doing for that. So it's they're not supposed to feed back exact content.
Hmm.
Now, they've scraped everything that's on the internet. They've scraped everything that's been digitized. Your picture of your Aunt Sally on your Facebook page is sitting in databases all over the world. Whether you do that or not, Aunt Sally is there. And, attributes of Aunt Sally may show up. Now, they're not supposed to feed it directly back in. They are the ones who potentially have infringed. So be careful of that. If you're using a thing for like Grammarly and all that,
Hmm.
for wordsmithing, and
Right.
AI is helping you wordsmith, it's helping you identify ideas. It's doing background. It's doing fact checking. It's all of those are safe. You could use AI for marketing all day long.
Yes.
So the chances of infringement, more likely you're not going to infringe. But the best thing is start with your stuff as the input into the AI platform. Don't go the other direction. Don't start with AI and then try to tweak AIs to make it sound like you. That's not going to be very successful in the long run. That's
Yeah.
the biggest risk. So start with your own content, your own words, your own work, and then use AI to tweak that. AI is a tool. It can
Hmm.
be used or it can be abused. And like I say, I use AI all the time. When I'm working with clients, I'll use it 20 or 30 times a day for that.
Hmm.
But I'm also not, I'm not going to put it out there and try to publish it. If I do publish it, then I have to claim what was AI generated, and it's just my copyright does not include. It's that simple. My
Hmm.
copyright does not include that AI piece, and anybody else can pick it up and use it. So where's the harm there? Well, I might see what I put in my book in somebody else's book. Well, I didn't create it, so I don't own it.
Right. That makes
Sounds
sense.
sounds fair to me.
It does. So, what should creatives do if they think someone has used their work without permission?
Rule one, make sure you have registered the copyright because you cannot file a lawsuit until you get the registration back. That
Okay.
changed in 23. That's a new rule out of the U.S. Copyright Office. So you have to have that piece of paper, and that's your certificate of registration. Once you have that, you can file a claim. Now, there is a small claims court, and you can win up to $30,000 judgment against someone for infringement.
Mhm.
You do not have to have that piece of paper in hand, but you have to file before you file the claim in the small claims court against copyright infringement. So the first thing is protect yourself. Do your own due diligence when you create your work, when you publish it, and stay within that 90-day window by all
That's
means.
that's great advice. And so for those of us who may not know, what is the best way to register our copyright? And the easiest cost effective?
Well, the it's called ECO. So it's lowercase e and then a big CO. So it's a copyright registration process online. Do it all online. The last thing I did cost me $65 to register for that.
Mhm.
It's in a process of revision. I don't know when we'll see it. It's a cumbersome, awkward, archaic process. The graphics look like they came right out of Pac-Man, and it was created in the 80s.
Yeah.
Looks like it's created. It's horrible. I think there are 28 screens. You have to input the same information 5 or 6 times. Although it's being revised, and it's going to be great when they come out with it. I've said it on webinars and all that. I don't know when it's going to be released. It's still in development process, and they're field testing and all that. But start with ECO. You have to set up an account. It's no big deal. You just want some basic information from you, and then file it. And you can do bulk filing. You could file 10 blogs at a time if you wanted to, and group registrations for that. So it's it's not rocket science. It's just cumbersome.
Mhm. Yeah. It's just another step for
Oh,
authors.
yeah.
Yeah.
The questions on the screen, then it'll come around and ask you the same questions over again. But you've got to go through the process,
Yeah.
and you can do it. You have to figure out what you're doing.
Yeah, that's great advice, and especially for someone when you're independently published, you definitely wanna make sure. Now, if you were with a publisher, they file that copyright on your behalf. Is that correct?
Yes, they should. Yes.
Yeah.
I would ask if you have because a lot of independent publishers, so you wanna make sure in, your agreement with whoever's publishing that
Mhm.
what they're gonna do and what they're not gonna do for that. It's just like getting ISBN numbers. Do you buy your own block of ISBN
You're
numbers
right.
or you're gonna use somebody else's? And I recommend buying them in bulk.
Yes.
Buy 10 at a pop. It's a whole lot cheaper than buying them one at a time.
Yes, for sure, for sure.
Yeah.
So can you share a success story or a cautionary tale of an author handling a tricky copyright issue? And you don't have to name names, but just maybe a general
It would give you the worst case scenario.
Yeah.
An author had printed 5,000 copies of a hardback book, and she's passing it out, doing talks and all this. And somebody says, "Did you get permission to use these 2 lines from a Beatles song in your preface that someone else wrote?" And she said, "That's not a problem, is it?" And she went to 3 lawyers, and they all said, "That's a problem." They came to me, I said, "That's a problem." So she came to us. We were able to secure permission for her to use those 2 lines from a Beatles song. And this was 15, 20 years ago. Cost her $500. She got
Wow.
off easy. They could have told her, "No, pull
Right.
that out of your book." She already had 5,000 copies made. She'd had to paste over all that preface. But anyway, she got permission. That's a worst case.
Yeah.
Uh,
A good cautionary tale.
do it early. Don't
Yeah.
wait till you're, don't wait. Don't even wait until you're in layout mode. Do this while you're developing the content as you go through, because it can take months to get permission.
Mhm.
Sometimes the cost is too high. Sometimes they don't like the way you're using it or where you're using it. They have the right
Mhm.
to say no if they own
Yeah.
the copyright for it. So give yourself time, give yourself budget. Talk to someone like me who's going to talk you out of doing the silly stuff. So
Yes.
it's time consuming and it's expensive. And
Yeah.
there are other ways that you can accomplish the same thing. Like you do your memoirs, cite the song title. Don't worry about putting 2 lines of the lyrics in there. People are going to remember you, Bohemian Rhapsody. You know what that is. I don't have to
Mhm.
sing the song for you.
Right.
Oh, so there are other ways to work around it. So I try to talk people out of a lot of stuff. And I've had the worst one. He was doing a memoir on his glory days of football. And he came to me and he had over 200 sources that he didn't know where he found.
Oh, wow.
And I said, "Well, if you don't know where you found it, how am I supposed to know where you found it for that?"
Mhm.
2 years later, he came back and he'd found all of them. So I ended up clearing over 600 different items for him for his memoirs because it was his football glory day. So he had all these press clippings and everything else. So, sometimes it takes time to do all this. So don't be in a rush. It's smarter to do it the smart way than having to go back and repeat and don't wait until you've got it in layout or it's already hitting the press before you think about permissions. Think about permissions before you start writing.
Great advice.
Nice. Yeah.
Yeah, I love it. And we are actually getting close to running out of time. So I want to make sure that we get to 2 more questions. First, tell us about the second edition of Copyright Clearance for Creatives. When we can expect it and when it's coming out.
The problem with this AI stuff, it's such a fast moving target.
Yeah.
I changed 3 slides in the last 2 days
Wow.
on a presentation I'm doing in June. I did a presentation on May the 21st. I've already changed 5 slides. Today is what, May the 28th,
Mhm.
because new things are happening, court cases and everything else. I'm going to have to debate only putting it in an ebook so I can go in and revise it constantly.
Yeah.
Now, I can put the basics, but then how do you keep it update? So
Sure.
we've got to sort through that. I'm going to have a lot of AI in our new version to illustrate AI, just like my presentation does, is I'm
Mhm.
illustrating AI as we go through that. So the best thing is go to our blogs. That's the most recent point of information, and it's real simple. It's just thecopyrightdetective.com.
Great. And I'll have these links. I'll have this link in the podcast description. And that was my next question. Where can listeners or viewers go to learn more or work with you directly?
Yeah, so the copyright detective, there's all kinds of contact us. in there,
Right.
and you just put a note in the line. I heard your podcast and got a question about XYZ. So we do consulting. Free advice is not a good way for me to pay the rent.
Yeah.
That was done a long time ago. If it's a simple question, I'll try to answer it. There almost never is a simple question,
Mhm.
and it's an onion.
Right.
An onion has many layers, and every layer can make you cry.
Yes. That's a great analogy.
And AI makes a much bigger onion.
Yes, it does.
By all means, ask the question.
Yeah.
And the problem is with copyright, and especially with AI, you don't know what you don't know.
Mhm.
So
Yep.
every presentation that I do, I tell the audience, you're going to have more questions when I'm done than when I start.
Yes, yes. I don't doubt that.
Yeah. Yeah.
Well, a big thanks to you, Dr. Miller, for joining us and sharing all of your insights on copyright and AI. I really appreciate you taking the time today to talk with me.
You're
Uh,
welcome.
yeah, and thank you, as always, for hanging out with us here on Miles Beyond the Page. Be sure to check out his website, thecopyrightdetective.com. If you like this episode, don't forget to like, comment, and subscribe. Hit the bell so you never miss a chat. You can also listen to Miles Beyond the Page on Spotify, Apple Podcasts, Amazon Music, and iHeartRadio. Until next time, keep chasing your dreams, and I'll see you miles beyond the page. Thanks for joining me on Miles Beyond the Page. If you enjoyed this episode, be sure to subscribe and leave a review. If you're an author and want to be a guest, visit michellemiles.net/podcast to apply. Keep writing, keep dreaming, and I'll see you next time.